Let's get started with special contracts from Indian Contract Act, law relating to bailment and pledge. Before that, if you're watching my video without subscribing to my channel, do subscribe and like the video. It motivates us to upload more. This channel runs on without monetization. We don't earn any income. My only purpose, I opened this channel to share knowledge among students to score good marks. All I need is your support, so subscribe and like my video. What is bailment? The word bailment has been derived from the French word balayer, which means to deliver. Bailment etymologically means handing over or change of possession. As per Section 148 of the Act, bailment is the delivery of goods by one person to another for some purpose, upon a contract, that the goods shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. Parties to bailment. Bailer, the person delivering the goods. Bailee, the person to whom the goods are delivered. The essential elements of a contract of bailment are: contract. Bailment is based upon a contract. The contract may be express or implied. No consideration is necessary to create a valid contract of bailment. Delivery of goods. It involves the delivery of goods from one person to another for some purposes. Bailment is only for movable goods and never for immovable goods or money. The delivery of the possession of goods is of the following kinds. Actual delivery. When goods are physically handed over to the bailee by the bailer. Example: delivery of a car for repair to workshop. Constructive delivery. Where delivery is made by doing anything that has the effect of putting goods in the possession of the bailee or of any person authorized to hold them on his behalf. Example: delivery of the key of car to a workshop dealer for repair of the car. Purpose. The goods are delivered for some purpose. The purpose may be express or implied. Possession. In bailment, possession of goods changes. Change of possession can happen by physical delivery or by any action which has the effect of placing the goods in the possession of bailee. The change of possession does not lead to change of ownership. In bailment, bailer continues to be the owner of goods. Where a person is in custody without possession, he does not become a bailee. For example, servant of a master who is in custody of goods of the master does not become a bailee. Similarly, depositing ornaments in a bank locker is not bailment, because ornaments are kept in a locker whose key are still with the owner and not with the bank. The ornaments are in possession of the owner though kept in a locker at the bank. Return of goods. Bailee is obliged to return the goods physically to the bailer. The goods should be returned in the same form as given or may be altered as per bailer's direction. It should be noted that exchange of goods should not be allowed. The bailee cannot deliver some other goods, even not those of higher value. Deposit of money in a bank is not bailment, since the money returned by the bank would not be identical currency notes. Duties of a bailer. Duties of bailer. The duties of bailer are spelled out in a number of sections: Section 150, 158, 159, 164. These are categorized under the following headings. First, bailer's duty to disclose faults in goods bailed. Section 150. In case of gratuitous bailment, the bailer is bound to disclose to the bailee faults in the goods bailed, of which the bailer is aware, and which materially interfere with the use of them, or expose the bailee to extraordinary risks, and if he does not make such disclosure, he is responsible for damage arising to the bailee directly from such faults. In case of non-gratuitous bailment, if the goods are bailed for hire, the bailer is responsible for such damage, whether he was or was not aware of the existence of such faults in the goods bailed. Duty to pay necessary expenses. Section 158. In case of gratuitous bailment, where, by the conditions of the bailment, the goods are to be kept or to be carried, or to have work done upon them by the bailee for the bailer, and the bailee is to receive no remuneration, gratuitous bailment, the bailer shall repay to the bailee the necessary expenses incurred by him and any extraordinary expenses incurred by him for the purpose of the bailment. In case of non-gratuitous bailment, the bailer is liable to pay the extraordinary expenses incurred by the bailee. Duty to indemnify the bailee for premature termination. Section 159. The bailer must compensate the bailee for the loss or damage suffered by the bailee that is in excess of the benefit received, where he had lent the goods gratuitously and decides to terminate the bailment before the expiry of the period of bailment. Bailer's responsibility to bailee. Section 164. The bailer is responsible to the bailee for the following: indemnify for any loss which the bailee may sustain by reason that the bailer was not entitled to make the bailment, or to receive back the goods, or to give directions, respecting them, defective title in goods. It is the duty of the bailer to receive back the goods when the bailee returns them after the time of bailment has expired or the purpose of bailment has been accomplished. If the bailer refuses to take delivery of goods when it is offered at the proper time, the bailee can claim compensation for all necessary expenses incurred for the safe custody. Duties of a bailee: take reasonable care of the goods. Section 151 and 152. In all cases of bailment, the bailee is bound to take as much care of the goods bailed to him as a man of ordinary prudence would, under similar circumstances, take care of his own goods of the same bulk, quality, and value as the goods bailed. Exception: bailee when not liable for loss, etc., of thing bailed. Section 152. The bailee, in the absence of any special contract, is not responsible for the loss, destruction, or deterioration of the thing bailed, if he has taken reasonable care as required under Section 151. Not to make inconsistent use of goods. Section 153 and 154. As per Section 154, if the bailee makes any use of the goods bailed, which is not according to the terms and conditions of the bailment, he is liable to compensate the bailer for any loss or destruction of goods. As per Section 153, a contract of bailment is voidable at the option of the bailer, if the bailee does not use the goods according to the terms and conditions of bailment. Not to mix the goods. Section 155, 156 and 157. If the bailee mixes the goods bailed with his own goods, with the consent of the bailer, both the parties shall have an interest in proportion to their respective shares in the mixture thus produced. Section 155. If the bailee, without the consent of the bailer, mixes the goods bailed with his own goods and the goods can be separated or divided, the property in the goods remains in the parties respectively, but the bailee is bound to bear the expense of separation or division and any damage arising from the mixture. Section 156. If the bailee, without the consent of the bailer, mixes the goods of the bailer with his own goods in such a manner that it is impossible to separate the goods bailed from the other goods and to deliver them back, the bailer is entitled to be compensated by the bailee for loss of the goods. Section 157. Return the goods. Section 160 and 161. It is the duty of bailee to return, or deliver according to the bailer's directions, the goods bailed without demand, as soon as the time for which they were bailed has expired or the purpose for which they were bailed has been accomplished. Section 160. If, by the default of the bailee, the goods are not returned, delivered, or tendered at the proper time, he is responsible to the bailer for any loss, destruction, or deterioration of the goods from that time. Section 161. Return and accretion from the goods. Section 163. In the absence of any contract to the contrary, the bailee is bound to deliver to the bailer, or according to his directions, any increase or profit which may have accrued from the goods bailed. Not to set up adverse title. Bailee must not set up a title adverse to that of the bailer. He must hold the goods on behalf of and for the bailer. He cannot deny the title of the bailer. Rights of bailer. Right to terminate the bailment. Section 153. The following are the rights of bailer. Right to terminate the bailment. Right to demand back the goods at any time. Right to file a suit against any wrongdoer. Right to file a suit for enforcement of duties imposed upon a bailee. Right to claim compensation. Right to terminate the bailment. Section 153. A contract of bailment is voidable at the option of the bailer, if the bailee does any act with regard to the goods bailed, inconsistent with the conditions of the bailment. Right to demand back the goods, Section 159. When the goods are lent gratuitously, the bailor can demand back the goods at any time even before the expiry of the time fixed or the achievement of the object. However, due to the premature return of the goods, if the bailee suffers any loss, which is more than the benefit actually obtained by him from the use of the goods bailed, the bailor has to compensate the bailee. Right to file a suit against a wrongdoer. Section 180 and Section 181 we'll see in detail later in this session. Watch it without skipping the video. Don't forget to subscribe my channel and like this video. Right to sue the bailee. The bailor has a right to sue the bailee for enforcing all the liabilities and duties of him. Right to compensation. If any damage is caused to the goods bailed because of the unauthorized use of the goods or unauthorized mixing of the goods, the bailor has a right to claim compensation for the same. Rights of a bailee. The following are the rights of the bailee. Right to deliver the goods to any one of the joint bailors. Section 165. If several joint owners bailed the goods, the bailee has a right to deliver them to any one of the joint owners unless there was a contract to the contrary. Right to indemnity, Section 166. Bailee is entitled to be indemnified by the bailor for any loss arising to him by reasons that the bailor was not entitled to make the bailment or to receive back the goods or to give directions in respect to them. If the bailor has no title to the goods, and the bailee in good faith delivers them back to, or according to the directions of the bailor, the bailee shall not be responsible to the owner in respect of such delivery. Bailee can also claim all the necessary expenses incurred by him for the purpose of gratuitous bailment. Right to claim compensation in case of faulty goods, Section 150. A bailee is entitled to receive compensation from the bailor or any loss caused to him due to the failure of the bailor to disclose any faults in the goods known to him. If the bailment is for hire, the bailor will be liable to compensate even though he was not aware of the existence of such faults. Right to claim necessary expenses, Section 158. In case of gratuitous bailment, the bailor shall repay to the bailee the necessary expenses incurred by him and any extraordinary expenses incurred by him for the purpose of the bailment. Right to apply to court to decide the title to the goods. Section 167. If the goods bailed are claimed by the person other than the bailor, the bailee may apply to the court to stop its delivery and to decide the title to the goods. Right of particular lien for payment of services. Section 170. Right of general lien, Sector 171. Rights of bailor and bailee against any wrongdoer, third party. Suit by bailor and bailee against wrongdoers. Section 180. If a third person wrongfully deprives the bailee of the use or possession of the goods bailed, or does them any injury, the bailee is entitled to use such remedies as the owner might have used in the like case if no bailment had been made, and either the bailor or the bailee may bring a suit against a third person for such deprivation or injury. Apportionment of relief or compensation obtained by such suits. Section 181. Whatever is obtained by way of relief or compensation in any such suit shall, as between the bailor and the bailee, be dealt with according to their respective interests. Termination of bailment. A contract of bailment shall terminate in the following circumstances. On expiry of stipulated period, if the goods were given for a stipulated period, the contract of bailment shall terminate after the expiry of such period. On fulfillment of the purpose, if the goods were delivered for a specific purpose, a bailment shall terminate on the fulfillment of that purpose. By notice. Where the bailee acts in a manner which is inconsistent with the terms of the bailment, the bailor can always terminate the contract of bailment by giving a notice to the bailee. A gratuitous bailment can be terminated by the bailor at any time by giving a notice to the bailee. However, the termination should not cause loss to the bailee in excess of the benefit derived by him. In case the loss exceeds the benefit derived by the bailee, the bailor must compensate the bailee for such a loss. Section 159. By death. A gratuitous bailment terminates upon the death of either the bailor or the bailee. Destruction of the subject matter. A bailment is terminated if the subject matter of the bailment is destroyed or there is a change in the nature of goods which makes it impossible to be used for the purpose of bailment. Finder of lost goods. Right of finder of lost goods may sue for specific reward offered Section 168. A person who finds some goods which do not belong to him, is called the finder of the goods. It is the duty of the finder of goods to find the true owner and surrender the goods to him. However, the finder of goods has no right to sue the owner for compensation for trouble and expense voluntarily incurred by him in finding the owner and preserving the goods found. But he has a right to retain the goods against the owner until he receives such compensation, and, where the owner has offered a specific reward on the lost goods, the finder may sue the owner for such reward, and may retain the goods until then. The finder of lost goods can ask for reimbursement of expenditure incurred for preserving the goods and searching the true owner. If the real owner refuses to pay compensation, the finder cannot sue but retain the goods so found. Further, where the real owner has announced any reward, the finder is entitled to receive the reward. The right to collect the reward is a primary and a superior right, even more than the right to seek reimbursement of expenditure. When finder of thing commonly on sale may sell it, Section 169. When a thing which is commonly the subject of sale if lost, if the owner cannot with reasonable diligence be found, or if he refuses, upon demand, to pay the lawful charges of the finder may sell it. When the thing is in danger of perishing or of losing the greater part of its value, or when the lawful charges of the finder in respect of the thing found amount to 2/3 of its value. The finder, though, has no right to sell the goods found in the normal course. However, he may sell the goods if the real owner cannot be found with reasonable efforts, or if the owner refuses to pay the lawful charges subject to the following conditions. When the article is in danger of perishing and losing the greater part of the value, or when the lawful charges of the finder amounts to 2/3 or more of the value of the article found. General lien and particular lien. Bailey's particular lien, Section 170. Where the bailee has, in accordance with the purpose of the bailment, rendered any service involving the exercise of labor or skill in respect of the goods bailed, he has, in the absence of a contract to the contrary, a right to retain such goods until he receives due remuneration for the services he has rendered in respect of them. In accordance with the purpose of bailment, if the bailee by his skill or labor improves the goods bailed, he is entitled for remuneration for such services. Towards such remuneration, the bailee can retain the goods bailed if the bailer refuses to pay the remuneration. Such a right to retain the goods bailed is the right of particular lien. He, however, does not have the right to sue. Where the bailee delivers the goods without receiving his remuneration, he has a right to sue the bailer. In such a case, the particular lien may be waived. The particular lien is also lost if the bailee does not complete the work within the time agreed. General lien of bankers, factors, wharfingers, attorneys and policy brokers, Section 171. Bankers, factors, wharfingers, attorneys of a high court and policy brokers may, in the absence of a contract to the contrary, retain, as a security for a general balance of account, any goods bailed to them, but no other persons have a right to retain, as a security for such balance, goods bailed to them, unless there is an express contract to the effect. Bankers, factors, wharfingers, policy brokers and attorneys of law have a general lien in respect of goods which come into their possession during the course of their profession. For instance, a banker enjoys the right of a general lien on cash, checks, bills of exchange and securities deposited with him for any amounts due to him. Banker can retain the jeweler given as security to the second loan towards the first loan which is yet to be repaid. Under the right of general lien, the goods cannot be sold but can only be retained for dues. The right of lien can be waived through a contract. Pledge. Pledge, pawnee and pawnee defines Section 172. The bailment of goods as security for payment of a debt or performance of a promise is called pledge. The bailer is in this case called the pawnee. The bailee is called the pawnee. Pledge is a variety or species of bailment. It is bailment of goods as a security for payment of debt or performance of a promise. The person who pledges or bails is known as pledger or pawnee. The person to whom the goods are delivered is known as pledgee or pawnee. In pledge, there is no change in Ownership of the property. Under exceptional circumstances, the pledgee has a right to sell the property pledged. Section 172 to 182 of the Indian Contract Act deal with the contract of pledge. Essentials of contract of pledge. Since pledge is a special kind of bailment, therefore all the essentials of bailment are also the essentials of the pledge. Apart from that, the other essentials of the pledge are: there shall be a bailment for security against payment or performance of the promise. The subject matter of pledge is goods. Goods pledged for shall be in existence. There shall be the delivery of goods from pledger to pledgee. Rights of a pawnee or pledgee. Rights of pawnee can be classified as under the following headings. Right to retain the pledged goods. Section 173. The pawnee may retain the goods pledged, not only for payment of the debt or the performance of the promise, but for the interest of the debt, and all necessary expenses incurred by him in respect of the possession or for the preservation of the goods pledged. Right to retention of subsequent debt. Section 174. The pawnee can retain the goods pledged for any debt or promise other than the debt or promise for which they are pledged. But he can exercise this right only when there is a contract to this effect. That is, a right to retain goods for subsequent debts can be exercised only when it has been provided for in a contract to this effect. Pawnee's right to extraordinary expenses incurred. Section 175. The pawnee is entitled to receive from the pawner extraordinary expenses incurred by him for the preservation of the goods pledged. For such expenses, however, he does not have the right to retain the goods, but he can sue the pawner for such expenses. Pawnee's right where pawner makes default. Section 176. If the pawner makes default in payment of the debt, or performance, at the stipulated time of the promise, in respect of which the goods were pledged, the pawnee has the following rights. The pawnee may bring a suit against the pawner upon the debt or promise, and retain the goods pledged as a collateral security. Or, he may sell the thing pledged on giving the pawner reasonable notice of the sale. If the proceeds of such sale are less than the amount due in respect of the debt or promise, the pawner is still liable to pay the balance. If the proceeds of the sale are greater than the amount so due, the pawnee shall pay over the surplus to the pawner. Rights of a pawner. As the bailer of goods, pawner has all the rights of the bailer. Along with that, he also has the right of redemption to the pledged goods, which is enumerated under Section 177 of the Act. Right to redeem. Section 177. If a time is stipulated for the payment of the debt, or performance of the promise, for which the pledge is made, and the pawner makes default in payment of the debt or performance of the promise at the stipulated time, he may redeem the goods pledged at any subsequent time before the actual sale of them, but he must, in that case, pay, in addition, any expenses which have arisen from his default. Duties of the pawnee. Pawnee has the following duties. Duty to take reasonable care of the pledged goods. Duty not to make unauthorized use of pledged goods. Duty to return the goods when the debt has been repaid or the promise has been performed. Duty not to mix his own goods with goods pledged. Duty not to do any act which is inconsistent with the terms of the pledge. Duty to return accretion to the goods, if any. Duties of a pawner. Pawner has the following duties. The pawner is liable to pay the debt or perform the promise as the case may be. It is the duty of the pawner to compensate the pawnee for any extraordinary expenses incurred by him for preserving the goods pawned. It is the duty of the pawner to disclose all the faults which may put the pawnee under extraordinary risks. If loss occurs to the pawnee due to defect in pawner's title to the goods, the pawner must indemnify the pawnee. If the pawnee sells the good due to default by the pawner must pay the deficit. Pledge by non-owners. Ordinarily, it is the owner of the goods, or any person authorized by him in that behalf, who can pledge the goods. But in order to facilitate mercantile transactions, the law has recognized certain exceptions. These exceptions are for bona fide pledges made by those persons who are not the actual owners of the goods, but in whose possession the goods have been left. Pledge by mercantile agent. Section 178. Where a mercantile agent is, with the consent of the owner, in possession of goods or the documents of title to goods, any pledge made by him, when acting in the ordinary course of business of a mercantile agent, shall be as valid as if he were expressly authorized by the owner of the goods to make the same, provided that the pawnee acts in good faith and has not at the time of the pledge notice that the pawner has no authority to pledge. In this section, the expressions mercantile agent and documents of title shall have the meanings assigned to them in the Sale of Goods Act. The necessary conditions of validity under the Section 178 are as follows. The person pledging the goods must be a mercantile agent. Mercantile agent must be in possession either of the goods or the documents of title to goods. Such possession must be with the consent of the owner. If possession has been obtained dishonestly or by a trick, a valid pledge cannot be effected. Pledge must have been made by the mercantile agent, when acting in the ordinary course of business of a mercantile agent. The pledgee must act in good faith. The pledgee should have no notice of the pledger's defect of title. If the pledgee knows that the pledger has a defective title, the pledge will not be valid. Pledge by person in possession under voidable contract Section 178A. When the pawner has obtained possession of the goods pledged by him under a contract voidable under Section 19 or Section 19A, contracts where consent has been obtained by fraud, coercion, misrepresentation, undue influence, but the contract has not been rescinded at the time of the pledge, the pawnee acquires a good title to the goods, provided he acts in good faith and without notice of the pawner's defect of title. Pledge where pawner has only a limited interest Section 179. Where a person pledges goods in which he has only a limited interest that is pawner is not the absolute owner of goods, the pledge is valid to the extent of that interest. Pledge by a co-owner in possession. Where the goods are owned by many person and with the consent of other owners, the goods are left in the possession of one of the co-owners. Such a co-owner may make a valid pledge of the goods in his possession. Pledge by seller or buyer in possession. A seller, in whose possession, the goods have been left after sale, or a buyer who with the consent of the seller, obtains possession of the goods, before sale, can make a valid pledge, provided the pawnee acts in good faith and he has no knowledge of the defect in title of the pawner.